So Donald Trump today, Trump versus U.S. in the Supreme Court. What is this case about, sir?
Yeah, so this case that is going to be argued today is former President Donald Trump has claimed that the special counsel investigation and prosecution ought to be barred and would extend that theory to virtually any prosecution because the president is arguably immune from any kind of criminal proceeding regarding official acts taken while president. And so that means two things. That means, first, that there's kind of a presumption of absolute immunity, no ability for a court to review, so long as those acts are official. The real question is what is an official act? Was the president's activities surrounding January 6th, were his activities regarding his presidential records, were those official? And obviously, the president and his chief counsel in this case, John Sauer, will make the case that everything was in fact official, and therefore traditional immunity doctrines ought to apply, and these prosecutions must be invalidated.
Where in the Constitution is this immunity part?
Yeah, so it's a structural, and I think there's really two strong arguments. One is that we look to the structure of the Constitution and we look to the history of the Constitution, and it creates a kind of obvious picture that in order for a president to function efficiently, he can't be kind of sued simply because he exercised his discretion. And so when you look at the Constitution, you see that there's a clear structure to it. The president is unique in the Constitution in that he is the sole head of the executive department. Article 3 of the Constitution makes very clear that there's going to be a Supreme Court and inferior courts. Article 1 of the Constitution makes clear that there's going to be a Congress. It's going to be a bicameral Congress. But only one article in the entire Constitution makes it clear that there will be a sole head of the executive department who will be democratically elected. And so that creates a very strong impression that the president must have a presumption of some level of immunity for official acts, for acts that are committed to his discretion. That's not to say that the president has absolute immunity when carrying out kind of mundane tasks or specifically legislative tasks. This case is not about the president's activities regarding expenditures that were authorized by Congress. That would be a different case. This is truly about official activities committed to his discretion. And historically, we have very strong bases for this. Look, in American history, President John Adams, who was our second president, he used the Sedition Acts to prosecute journalists. And no one would have said, well, Adams' prosecutions of journalists, and he did multiple indictments of these journalists, put them in prison because they said things that he didn't like. And no one would have said, well, Adams should now be subject to prosecution for those acts. The reality is that there was a very clear remedy if you didn't like what the president was doing. And it was elect him out of office. That was the clear kind of constitutional remedy. And then, I think the last thing I would say is, look, we have very clear language in Article 1, which talks about Congress, about the official acts of members of Congress being protected by the speech or debate clause. Now, you don't have a specific kind of clause regarding privilege in Article 2. You have something very interesting, which is that there's a mandate that the president give a State of the Union. And the president is able to, it must give this State of the Union, and as a matter of tradition, is something that's presented to Congress. And that's a strong indication by the founders that the president, when going to the floor of the United States Congress to update them about his kind of official acts, should also be entitled to some level of speech or debate privilege. And as applied in this case, I think it's a very strong signal that when the president engages in official duties, he should be entitled to a presumption of immunity. The last thing I'll say, and this is an argument that the president has made that I think is quite persuasive, is that if you look at the clauses in the Constitution regarding impeachment, there's something that, and I think this is what is known in the legal community as the impeachment judgment clause. But the impeachment judgment clause is very clear that the president shall not be subject to any kind of prosecution unless and until he has been convicted or non-convicted by the Senate for the parallel crimes. And, impeachment is for high crimes and misdemeanors. And so the argument is, look, if you believe that the president obstructed justice, which is really the claim in Florida, or you believe that the president engaged in kind of a conspiracy over false electors, which is the theory in Georgia and Arizona now, or if you believe that the president kind of obstructed official government functions, which is the argument in the DDC by the special counsel, then you have all of these opportunities to create 4 or 5 or how many articles of impeachment over those issues via the Congress. Congress can do it now. Congress could have done it when he was still in office. And you can have an impeachment proceeding. And only until that proceeding is finished, either it leads to a conviction or it leads to an acquittal, then the prosecutors can get their hands around indictments and proceed after the president. But not until then. And that's going to be, I think, a very persuasive argument to the court.
Okay, very good. That John Adams point you brought up is very interesting because I've read a ton of headlines about how this is unprecedented. This has never happened before, this question. And I heard one argument on somewhere that the fact that it's taken almost 300 years in order for this question to be presented just proves how wicked and terrible and evil Donald Trump is and what he did. But I don't think that's the argument at all. If you brought up that John Adams, let me throw in Andrew Jackson. Was Andrew Jackson ever criminally prosecuted for the Trail of Tears?
Yeah, of course not. Of course not. And this is, I think, it's an unfortunate reality that many individuals, and I saw this. I was a lawyer in the Trump White House. It wasn't even a question of day one of the administration. We were already under kind of undue political assault. The undue political assault started during the presidential transition. We had already received congressional inquiries from former Oversight Chairman Elijah Cummings. And, then you have the special counsel investigation that's already beginning during the transition, at that point led by former FBI Director James Comey. And so it has been a kind of piece of Americana to an Americana by kind of liberals to just attack Trump at every corner. And I think it's an unfortunate episode because it really shows a deep ignorance of American political history. One of the things I have is a PhD in political science, concentrating on American politics, and there's a rich history of this country of presidents, and whether if we look back as a matter of history, whether we look at it as kind of woeful episodes, but independent, there's a very rich history of presidents doing things that we don't happen to like. But what we say under a rule of law system is that there's a very clear remedy, and it's called elections. Right? John Adams prosecuted journalists through the Sedition Acts. Jefferson got rid of those Sedition Acts. But at the same time, Jefferson, actively owned slaves. You had Franklin Delano Roosevelt, who, interned Japanese individuals effectively at concentration camps in the borders of this country. You mentioned, Andrew Jackson. These are all maybe unfortunate episodes of American history, but never before have we said that we're going to now prosecute the president for doing what he believed was his prerogative as the most democratically elected individual in this country. And it makes me very concerned that those critics of Trump are really, truly, deeply critics of democracy.
Well, they would say the same of you, sir.
Yeah.
So I don't have a PhD in poli-sci, but I am on a Wikipedia page entitled
that's even better.
Presidential Immunity. It's these days it might be. And it has here a couple sections about Nixon and Clinton v. Jones. What are the parallels or connections at all that we can learn from those cases?
Yeah. Well, I think the first thing about, let's just take the Nixon case. So the Nixon case is very squarely about a special counsel investigation, but a special counsel that was unique. It was done under a provision where you had kind of a Senate investigative committee that was really coordinated with a quasi-executive branch team. And there was no actual litigation process against Nixon. He resigned. And so we didn't have to deal with the big kind of legal question as to whether the president can be, criminally prosecuted, go through trial and get a conviction. And so, I think that's unique on a number of grounds. Number one is if we probably, even had that happened, I think the court would have very kind of quickly gone in and shut down any of that kind of process. And the reason is unique there is that there was ongoing impeachment proceedings, right? It was the impeachment proceedings, not the Leon Jaworski special counsel investigation that ultimately led Nixon to resign. The impeachment was viewed as a much greater threat, not the Leon Jaworski special counsel investigation. The second clear thing is that we actually have, from the benefits of history, the ability to look at who was then Assistant Solicitor General Robert Bork's briefing in various cases regarding the special counsel investigation. And he said very clearly that the president has absolute immunity from criminal prosecution.